A young boy from Kerala who studied zoology, then law, became a judge at the Kerala High Court and then took to the reins of the Supreme Court of India. I have with me Justice CT Ravikumar, who's recently retired from the Supreme Court, one of the finest judges when it comes to the Supreme Court of India. A man with a clean and a very, very calm demeanor when he was on the bench. Sir, welcome to CNN News 18.
Thank you.
Sir, my first question to you is, how has this 3 years journey at the Supreme Court and this long journey at the bar and the bench been?
I started my journey in judgeship on 5th January 2009 and it culminated in 5th January itself, of course in the year 2025. One cannot say that it was a very, very smooth journey, but still, of course, in the case of everyone else, we also had to face so many difficult situations. But then, of course, you know that I could survive everything, and grace of God, without any controversy, I could demit the office.
Sir, you were appointed by a collegium system. Every judge at the Supreme Court or the High Court is by way appointed the collegium system. But there were a lot of questions raised when it comes to collegium. They said that it needs a reform, it's a very old system. Do you think that there is a need of reform in the collegium system, or is it working fine itself?
Being a selective of this system, I cannot find fault with the system. And again, according to me, see, to judge a person whether he is competent and qualified to be elevated to the bench, who else can assess a person than the judges? Of course, the senior judges who form or constitute the collegium, definitely they will be getting an opportunity to assess that man, because he is performing before them. And the kind of case, the kind of complexity involved in a matter, and how he presents it, how he thinks, everything will be assessed. His demeanor, everything. So that they're having the first-hand knowledge about that particular person. They are assessing him because he is performing right in their front. And most of the others, they are only hearing about him, or maybe having an opportunity to see him performing. But then, what was the case before on hand, and in what manner he performed in that case, and all those. And when the judges themselves assess it, and ultimately, after analyzing everything, finds that he is competent, it's a good thing according to me. But then, of course, there may be something there. You cannot say that lapses or latches from the part of the members or whatever. System, of course, it needs some improvements in the sense everyone should be having an opportunity to. And in that sense, virtually it is for the persons, that means the advocates. They have to establish while practicing, yes, I am a fit candidate and I should be in the reckoning. And once a person establishes himself, he should be having an opportunity. That means he should be in the zone of consideration. So you will have to bring yourself within the zone of consideration. That's it.
Sir, while we speak of the zone of consideration, there is one point in the collegium system and it's a part of recent talks itself, which is with regards to reservation. And more than you, I think nobody can shed light more on it. You come from a community and have made your mark on the world of judiciary so well. So do you think that reservations, at least in judicial appointments, is something that is warranted or should not be warranted, or what should be the criteria for judging a judge?
See, that question, of course, I can answer only in one way. See, whatever be the source of appointment, in the sense, if you are saying that no, some reservation should be there, reservation for women or the marginalized persons or particular community, etc. And ultimately, they have to perform and they have to discharge the same duties. So for discharging this duty attached to this particular position, a required a standard is there. The competence, qualification, etc. there. So it is one and the same for everyone. But at the same time, persons from different categories, if they are there, the quality also will improve. Because see, in the case of women, and of course they will be the best because they themselves are belonging to that category. In a better way, they can understand the difficulties. Likewise, if a marginalized person, since he came from that, he can understand the difficulties, whatever it be, all those things. So the thing is identifying the best candidate who satisfies these qualities and qualifications. And once you can identify such persons, it is better to select persons from different these kind of communities.
So another point that is coming up from the whole appointment process is one that we recently saw, that a senior member of the Collegium said that there is a nepotism that should be avoided when it comes to judiciary. There should not be judges' kids should not become judges, or judges' relatives should not become judges. How do you see that as well?
See, to be fair with this question, my answer, I should say, how can you say that a son of a judge or a son-in-law of a judge or a daughter or daughter-in-law of a judge or some other kith, they should not become a judge? That means we are actually saying against the Constitution. Because what are the qualifications to be satisfied for being in this sort of consideration and ultimately to become a judge? It is there. When that is there, being a relative or a very close relative of a judge shall not be a disqualification. But at the same time, that shall not be a qualification also. A fair selection should be there. Now, otherwise what would happen is a person who is very competent and qualified to be a judge in all respects, simply because of the fact that he is a relative of a judge, if he is put outside this sort of consideration, that will be a loss to the judiciary. So that this shall not weigh with the minds of the collegium, the persons who are selecting him. That I can say. But totally not considering them simply for this reason, my humble submission, view is that that shall not be.
So, there have been various instances where certain sitting judges have given out certain statements which are a little controversial, or they are a little demeaning to a particular sect or a community or a religion. And the most recent case, of course, is of Allahabad High Court, where the Collegium also called him. So do you think that somebody who's on a constitutional post like that of a judge, because he's ultimately deciding cases, should actually go out on a public platform and give out such statements?
See, one thing which I practiced till today, or till I demit office, was never unnecessarily poke my nose in a matter where I am not having any say. This particular thing, of course, it is already taken up by the Collegium, and I know that they will handle it in accordance with the law. Having said so, I am of the firm view that a judge has to show this self-restraint, because we do not know what matter would ultimately come up before you for consideration. And it is better to avoid any comment, because ultimately, if you made a comment and if such a matter at a later point of time comes up for your consideration, even if you are taking a decision in accordance with the law, still people may think, no, whether if he is taking a decision based on his previous comment, then of course they may think that yes, he has already expressed his view, he is taking a decision in accordance with that. If he takes a different view, then also people may think, why he already expressed his opinion, why he is changing, anything happen in between. So it's better to restrain yourself.
We see a lot of live streaming of court proceedings happening these days, but a small problem that has come up is that the general people, the general public, or many criticize the judges for their questions that they ask, and they are seen as a final verdict of a particular court by the general public or people who are out in the open. Do you think that this is a big disadvantage of the live streaming and can turn up things in somebody else's favor, or can influence a particular case or a judge?
See, live stream, it is good according to me, because people knew now that what is actually happening in courts. And this is, of course, the public, they have a right to know that. And again, the question, the crux of that, I think that it is about understanding the way in which the procedures are being conducted in a court. The questions, of course, it's being put to the counsel concerned with a view to enable him to present a matter on which something is passing or crossing through the mind of the court, right, which the court may think which it is relevant. Sometimes that particular person may be able to establish that that is not that much relevant as the learned judge thought. In another way, of course, you know that the pressure of work of a judge. On a given day, we are dealing with some 60-65 matters. But as far as a lawyer is concerned, he may be having maximum 5 or 6 matters. So he will be able to put more time on any matter. In such circumstances, if a particular thing or a particular point may skip the attention of the court, that particular judge, so when we are putting a question, he will be able to answer that. And if a particular decision which is very pertinent, which is very relevant as far as that particular case is concerned, he will be able to answer that. If a particular relevant provision that also missed the attention of the court, he can. If the court is sitting silent, how he will be able to? So we are not putting these questions after forming an opinion. This is a method by which we are actually ultimately getting into the truth of that matter. So if that understanding is there, merely one question, ultimately after analyzing everything, and we may think that yes, that need not be gone into, and this matter can be better decided without going into that question. So you need not have to form an opinion that this question was asked but that is not there. Ultimately in the judgment, what is relevant for consideration, that alone need be there.
So another trend that is actually going around, and I've asked this to a lot of ex-judges as well, is that there is a recent trend that has come across of not criticizing the judgment but the judge itself these days. If somebody, especially on social media, people are saying a lot of things about a particular judgment, but they are now attacking the judge itself. Have you faced such a thing in your career, and how do you deal with such a backlash, if at all it has happened?
See, I never had to suffer any this kind of attack by media, social media, in this. Maybe because I'm not on WhatsApp. Maybe I'm the only one who is not using WhatsApp. There are several reasons. I thought that while I was in office, sometimes if a important matter comes up before you, in the form of suggestions, you will be getting so many messages, all those things. I thought that such things shall not weigh with me. And what all things before me, and in accordance with the law, that alone should be the materials for my decision. Any suggestion or anything of some outsider, that shall not weigh with me. And there are other reasons also. But now come to this, any decision, in another chance also I said, any decision of public importance should be made as a subject for a discussion, because it is required. Development of law would take place if constructive criticism is made on a judgment.
Right.
It is required. But it is for the persons who make such criticism to bear in mind that we are actually criticizing a judgment and not the judge. So a fair criticism, a constructive criticism on a judgment, that will improve. Because on a later point of time, if a similar matter comes up for consideration, and if a particular angle or which was also was available, but that was not actually gone into in the earlier judgment, then the judge will be getting another opportunity as to consider whether that is also relevant. So constructive criticism will enable development of law, but this scathing criticism of a judge or a judgment, that has to be avoided.
So last two questions before I let you go. One, that you were a part of, in fact, a judgment of the classic Vijay Madan Lal Chaudhary judgment, which upheld the powers of the Prevention of Money Laundering Act. But there has been a recent trend, and this is the view of the general public, that somewhere or the probe agency has overreached its power that it was given by the Supreme Court of India. Do you believe, seeing the recent cases itself?
First of all, I was a member of that particular decision rendered on PMLA, and now a review petition is pending. So I do not want to make any comment upon that, because when a matter is still under consideration, I think that I should refrain myself from making any comment upon that.
So last and final question, it's an interesting one. We see the advent of artificial intelligence coming in. Do you feel that one day AI can also replace a judge?
I don't. I'm very emphatic on that. I don't. Just because, we are actually calling upon to take decision or adjudicating on matters where the grievances of a human being, whoever it be, a decision is to be taken on that. Sometimes it may be a matter where pure question of law alone is involved. But there are some matters where, apart from that, there may be scope for or there is room for considering it in a different angle, some humanitarian sympathy, compassion, etc. How can a machine or this kind of a thing decide a matter giving consideration for these humanitarian aspects, that is sympathy, compassion, etc. That of course has to come from the mind of the judge concerned while considering the matter, taking into account the factual situation involved in a particular matter. Of course, I am of the view that this intelligence, this AI, of course, you can take aid of that, so that it will definitely, we are all saying about speedy justice. Yes. So it will definitely help you to have this speedy justice, true. But at the same time, your intelligence, you must understand this also, I said so many times, you must understand that this artificial intelligence is also an invention of a human being.
Right.
So whose intelligence is superior? I believe it is human intelligence. And again, while simply merely relying on this artificial intelligence, you are making your intelligence, that is the human intelligence, artificial. That shall not happen. Because you will have to decide matters taking into consideration the given facts, the law and the humanitarian, because after all everything is for human beings, the law. And that humanitarian touch should be there to make it a perfect judgment, which an AI cannot.
This was Justice CT Ravikumar who was speaking to us. It was a lovely talk with you, sir, and a lot of insights on law, on how there could not, on the nepotism in law or reservation in law, whether it comes to AI and how the advent of AI can affect the legal fraternity. Justice Ravikumar has shed light on that. I am Anand Bhatnagar with video journalists Narendra and Ravinder for CNN News 18.